Welcome everyone. I think we are ready to let everyone in the room. And yes, I see a question already in the chat to give you all permission to record. Yes, we surely can. Evan is here to help out with the technical pieces. So if there's anything you need, you can message Evan directly during that time. This will also be recorded out on our end, and we will be publicizing this and putting this in the release as well, in case you do miss anything. All right, well, let's go ahead and get started. My name is Chelsea Higgs-Wise, and I am the Executive Director of Marijuana Justice. Here at Marijuana Justice, we believe that equitable legalization is truly the gateway to dismantling the war on drugs. And in 2019, Marijuana Justice was founded due to the call for reconciliation after 400 years since our African ancestors were trafficked right here to the shores that would later be colonized as the Commonwealth of Virginia. Racial justice organizers reflected in 2019 on our history and what was going on currently, and we answered the call to what we heard were opportunities for liberation, justice, and reinvestments. So Marijuana Justice has formed, and our strategy of repealing the prohibition, repairing people's records, and resentencing for release, plus the reparations model to redistribute the tax revenue is why we exist. Because in 1971, when Nixon's administration enforced prohibition targeting Black communities specifically, Virginia mimicked the racist policing, the prosecution, and the sentencing that the Commonwealth's carceral system then tripled down on in the 1990s. For years, Virginia prosecuted tens of thousands of people for possession that were disproportionately Black until 2020, when we decriminalized marijuana. But during that 2021 session this last year, our coalition helped to uncover that the decrim laws passed in 2020 did nothing to lower the desperate rate at which Black residents in Virginia are continuing to feel the penalties, 4 times the rate compared to whites in Virginia. What this reminds us is that marijuana laws were rooted in their foundation to disrupt Black and Brown communities, and they've been doing this in full effect for decades. So the public and the legislators can now guarantee that any future marijuana enforcement will follow the trend of the racist war on drugs. Our coalition letter last year gained the support of over 25 organizations to legalize it right in Virginia. And how we left the law on April 21st of 2021 was a much further step towards equity than what's moving in the legislature today. Today's legislation is just one simple step of legalizing it, not to legalize it right. Now that we have repealed the prohibition of possession, we are here to remind Virginia of the call to legalize it right and demand a strategy of day one equity. Day one equity means that the people in prison are resentenced with a meaningful release strategy. It means that the number of social equity licenses are listed. We recommend at least 50% of the licenses are social equity. We want to talk about and see that the money that is allocated for the Social Equity Business Loan Fund is upfront, and that capital is accessible for social equity operators to apply ahead of time and use those funds to participate in day one sales. The next sensible step that did not happen last year is to resentence and reunite the families still locked in a cage for weed possession. What resentencing could look like is what Senate Bill 745 is doing right now, which automatically provides a hearing for those still incarcerated for a sole marijuana offense. And for those with a sentence enhancement, it provides a parole hearing within 1 year of this law being passed. Now, the parole board is not our favorite approach, but it does provide a pathway that we know has to be our focus in this year's session. So what's going on is that we have 2 main bills that we are really here to watch on the legalization, and Senate Bill 313 is just something that we have to have stopped. And what we are looking for in Senate Bill 391 is that what we want to have it amended with no new crimes. And we want to make sure that our bill is enacted to ensure that we have day one equity. So I want to continue this conversation with our CannaJustice Coalition and our guest and our partner in justice, Minority Cannabis Business Association. Today we have Amber Littlejohn here with us. But first, I want to continue to introduce our CannaJustice Coalition. And up next, we have Valerie Slater of Rise for Youth. Thanks so much, Val.
Good morning, and thank you all for being here with us today. And I'm going to talk about a little bit further about the whole resentencing component. And what's really important for us to note is that when we look at resentencing, it should be an automatic. We ought to automatically have individuals that have been sentenced. We ought to automatically have them appearing to have their sentences vacated or significantly reduced. If an individual, and when we look at Senate Bill 391, it says that a person who has been convicted and their conviction was related exclusively to marijuana, that there is 1 year within which they will indeed be back before the court, but that sentencing court. But what is disturbing is that it says that the court may reduce or alter their sentence. So if indeed we are looking at equity, we should be saying that if an individual is incarcerated on a felony, on a marijuana charge for an amount that is no longer illegal, why is it then discretionary for the court to potentially reduce that sentence? There's a problem with that. And Chelsea is absolutely right. Right now, we may have to refer to the parole board for individuals who have had an enhanced sentence because there was another charge involved. But quite frankly, when we look at individuals who have been sentenced, it's a court that handed out that sentence. It wasn't a parole board. And so when we review cases for resentencing, it should be the sentencing court and not a parole board. We are all of a sudden giving judicial authority to a parole board to change a sentence. And we ought to all take issue with that. And then, that isn't even to mention, we left the crimes for kids in the original bill. And so now we have the potential for these children, and especially if there is an incident relating to school property, this is a class 3 misdemeanor. We are looking at the potential for kids to end up in front of judges with sentences, on probation, all of this range of potential outcomes for children, all of which at this point have ignored the fact that we're talking about kids. And our number one concern should be making sure that they are okay. Why are they involved in an industry of marijuana, whether it's use or they just have it on their person, their possession of, or they are using? We ought to first be asking the why. And once we understand the why, we need to begin to address whatever underlying issue is involved with that young person. Criminalization of children, we ought to flee it. We ought to instead embrace children and find the ways to ensure that they are going to be successful in their lives, successful in education, finding career paths that are going to lead to the fulfillment of their dreams and desires. And so when we look at SB 391, we ought to be saying we've got to amend the way we are allowing the resentencing to happen. And I know that it's not even up in any of the bills this time around, but we've got to review what we're doing to children. We've got to roll back the criminalization of childhood and instead begin to support our children. We've got to love children. Let them know that, you know what, if you are struggling, we are here for you. And we don't have a police officer, some cuffs, and a jail cell for you. Thank you so much, Chelsea.
Thank you so much. And up next, we will have Kalia Harris with Virginia Student Power Network.
Hey, y'all. Good morning. As Chelsea said, my name is Kalia Harris, and I'm the Executive Director of the Virginia Student Power Network. We are a statewide organization that represents hundreds of college-aged young people throughout Virginia. Now, Virginia legalized simple possession of marijuana Yet, Virginia residents remain incarcerated for marijuana-related convictions. I'll say that again. Virginia residents remain incarcerated for marijuana-related convictions, despite the fact that we've legalized simple possession of marijuana. The next step after legalization is to resentence and release individuals still incarcerated and under surveillance for marijuana-related offenses. We need legislation that addresses the harm being inflicted on those who are still incarcerated and under supervision. People that would benefit from resentencing and yield the most relief from the marijuana enforcement that's adding to the separation of our families and caging our loved ones. We must adopt legislation that Virginians can be proud of. That means championing equity from day one, and the data is clear. Black and brown youth aged 18 to 25 are the most impacted by marijuana enforcement in Virginia. We cannot and we must not legislate new crimes with marijuana possession or other felonies that come with prison time. Young people in Virginia, including students on college campuses, are already trying to navigate the educational institutions that have varying and very unclear policies and punishments for marijuana-related incidents from campus to campus and off campus, where law enforcement jurisdictions can and do overlap. Our youth's future can be severely impacted by these marijuana-related fines, arrests, and convictions. Current and potential students can lose access to federal financial aid to pay for school, not be eligible for public housing, miss out on countless employment opportunities, not to mention the fact that marijuana-related offenses are the fourth most common reason used to deport people from this country. The proposed legislation would change the penalty for possessing between 1 ounce and 1 pound from a civil penalty to a misdemeanor, from a civil penalty to a criminal offense for anything between 4 ounces and a pound of marijuana. Legislating new crimes associated with the possession of marijuana is working backwards, y'all, backwards, and will continue to empower racist policing in Virginia. So we must protect our progress and continue to legalize it right in Virginia with equity on day one. No new crimes for marijuana in Virginia. Thank you.
Thank you so much, Kalia. Up next, we have Ashley Shapiro with Justice Forward Virginia.
Good morning. So I'm here on behalf of, as Chelsea said, Justice Forward Virginia, a criminal reform nonprofit. I'm going to change gears a little bit and discuss with you all HB 79, which passed the House of Delegates just this past Friday. And just as Kalia said, we need to protect our progress, and this bill is doing the exact opposite. It is perfectly legal for the police to stop someone for completely racist reasons, so long as they find some other excuse, some other infraction to cover for their racism. The phrase driving while Black is a very real thing in this world. And what happens at these stops? At a minimum, the personal safety and autonomy of people of color is at risk. At a maximum, ask Sandra Bland, ask Philando Castile. Their lives were taken in what should have been a routine traffic stop. The only way to stop these killings and the complete disregard for people's constitutional rights is to eliminate the power of the police to use their biases as a basis to pull someone over. So in 2020, the General Assembly did just that. They took away the most flagrant abuses, the dangling objects, the third brake lights, infractions that have nothing to do with public safety, and were instead the most egregious bases for these protectual stops. Eliminating protectual stops, or at least the vast majority of them, had an immediate and incredibly impact that we could see and measure. Thanks to the Community Policing Act, we already have data showing that the pretextual policing bill has been successful in minimizing the disproportionate targeting of people of color by the police. Prior to the bill, Black people were disproportionately targeted, making up only 20% of the population, but 30% of stops, 43% of searches, and 37% of arrests. A vast majority of those searches were based on the supposed odor of marijuana. Even after it was decriminalized, they were still allowed to search. People of color are 2.4 times more likely to be stopped in the first place than a white person. But in the 4 months that we have data between March and June of 2021, that gap has already lessened and become more proportionate. Yet Republicans want to roll back this step toward equity and fairness, barely a year after it went into effect. Why? As I heard Delegate Patrick Hope speak on Friday, who sponsored the original legislation, this repeal is not something we'll look back and say it had unintended consequences. We know the consequences. We know the impact of this legislation that has already had in protecting people of color from these race-based police stops. No, this repeal has a very clear consequence: to give police back the power to use racism as the basis for their stop and to be able to legally cover their tracks. This bill has to be defeated.
Thank you so much, Ashley. It is a very important circle that we connect with advocates all across the Commonwealth that are touching different issues of our people that then touch the plant. And as we're talking about vehicles and safety, that is also part of our legalization process. And where we're moving towards now is I'm going to bring on Amber Littlejohn of Minority Cannabis Business Association. And the reason why our CannaJustice Coalition has been partnering with MCBA is because of what we saw and are seeing in Senate Bill 313, which really creates this new system that Amber is going to talk a little bit more about, that we know is not just dangerous for small entrepreneurs, but will increase the disparate enforcement in our communities, and the same type of impact that Black and Brown communities have been having on the war on drugs prior to the repeal of prohibition will continue to feel. So this is why it is so important for us to be part of this conversation with how legalization happens with legal sales as well. And I'm really excited for you all in Virginia. If you have not met or heard from Amber or what they're doing with MCBA, they were one of the first groups I went to when we formed Marijuana Justice, just to look at the model ordinances that they've been putting out. They continue to put out information for advocates like us, for organizers like us to stay tuned. And just last week, they put out a crucial report for where equity stands in the nation. So again, I just want to quickly, that was my quick introduction, but there is no quick introduction truly from Ms. Amber Littlejohn.
Thank you, Chelsea, and thank you for the opportunity to be here today and to speak to the folks in Virginia. As Chelsea mentioned, my name is Amber Littlejohn. I am the Executive Director of the Minority Cannabis Business Association. We are the largest trade association dedicated to serving minority cannabis entrepreneurs and our community. This is a bit of a pivot. We've been talking about the criminal justice elements that have been under attack here, but it's important to remember that the harms of prohibition have been broad, so the reparations and the fix has to be large as well. And we look at equity in 4 pillars, including criminal justice reform, access to the plant, community reinvestment, and industry. So SB 313 is an attack on the industry component and an attack on the chance to economically empower and restore the communities that have been most impacted by cannabis prohibition. And what we're seeing, a report actually put out the week before, we are seeing a wonderful wealth and information coming out of our community. A report put out the week before by Supernova Women talked about the fact this isn't just a moral imperative, but for every dollar that a state spends on equity, there is a $1.20 return, because these are businesses that give back to their communities. These are businesses that uplift and support their communities. So it really isn't, again, just about the moral imperative. It is about the best thing for Virginia and Virginians. We've seen these repeated attacks that others have mentioned on equity, having one lawmaker even call the social equity program in licensing the Give a Felon a License program. This is a program, again, designed to provide opportunities for those who have been most impacted by Virginia's disparate enforcement of cannabis laws. Proponents of SB 313 claim that this will eliminate the unregulated markets, but this has been done before, and that has never held true. Oligopolies and captured markets are one of the #1 reasons that lead to the proliferation of the unregulated market. For instance, California provided early access and had highly limited municipal markets, and they are currently battling against an unregulated market that makes up almost 80% of cannabis sales. There are 11 states that have provided early access to cannabis businesses to medical operators. And mind you, medical operators are almost exclusively large companies and large out-of-state companies. And 11 of those have actually happened in social equity states. Never have we seen a market decline in the unregulated market. In fact, there is incentive when the market is captured by a few for those who don't have access to take it. We have also never seen evidence that equity comes after early access to the market. In fact, in the state of Illinois, that was previously the beacon of social equity, medical operators have had a 3-year head start, while social equity operators have been marred in lawsuits, legislative delays, political finagling. And so 3 years later, not one single social equity retail business is open. And this head start and market capture has continued for this handful of companies. Currently, African Americans make up only 2% of plant touching owners in the cannabis industry. 2% of owners in the cannabis industry. And this is due to policies like this that create systemic inequities and extraordinary barriers to entry that social equity programs can barely touch. And Virginia, instead of fighting to repair and hold tight to what provisions we have and to the funding that we have for social equity operators, is instead pushing to provide early market access and to facilitate the market capture and oligopolies for a handful of companies. In addition to early market access, it's important to note that these companies around the country not only receive early market access, but they receive exemptions for local opt-ins, essentially, again, protecting local monopolies and oligopolies. They receive exemptions to vertical integration bans, meaning they can benefit from scale while others cannot. There are also extraordinary barriers to entry into the medical market, including almost universal bans on participation by individuals who have been incarcerated for cannabis offenses. The cost barriers to entry also for the medical market and vertical integration requirements, again, provide extraordinary barriers to entry. We are not opposed to early market access. We just believe that if these companies can open on day one, then the businesses they incubate can open on day one along with them. And if the laws can be changed to make that happen, then the laws can be changed to provide access to the market on day one. We ask you again to oppose SB 313 and help ensure equity on day one.
Thank you so much, Amber. I believe those are all of our speakers. If want to really just make sure that everyone has gotten a chance to see our letter, and we will be putting that out very publicly. Right now, we have over 35 organizations that have signed on to our letter. Many of them are on this call right now. If you are part of an organization that has signed on, if you can just drop your org name and say hello and where you are in the Commonwealth, that would be great. And I am now really willing and excited to open up the floor for questions from press. Hi, Whitney, you can go first. You can take your mute button off if that's helpful.
Hi, good morning. I guess very, basic level question here is, are any of these bills, positive or negative in, for your organizations going to survive crossover? I mean, do you anticipate it?
That is a very good question. And so right now, we're not sure what the House's plan is. This is why we're really focused on the resentencing part of marijuana, because right now resentencing is a separate bill and it's going to go into the larger one. But we know in conference, once that happens, even after crossover, this could be something that could be a pawn. It could be a negotiating tool. We do know that there is some motivation to have the legalization bill passed, as last year meet some of the reenactment qualifications. but I am unsure that any of them will survive. And so we're really just hoping that we can make sure that we do satisfy the enactment so that we can continue to build on to the plan that we had started last year in 2024 that was much more equitable.
Thank you.
Does anybody else on the coalition want to address Whitney's question? But we are really eager to see what the House has planned, as they have not docketed any of the marijuana bills and have said very directly that they are waiting to see what happens in the Senate. So we are also waiting to see what happens in the Senate, and we know that there will always be some type of compromise to get legalization going. So we want to ensure that equity isn't compromised away for day one, nor is our resentencing and reuniting families. And that's what we're really here to push right now.
It's really, again, unfortunate that we, last year, it was equity that really drove legalization. And now here we are bargaining away just human rights and bargaining away liberty and bargaining away reparations. And this is not unacceptable. And this is a position that I see us put in around the country time and time again. And the promise is always, we'll make it better later. Don't worry about it. We'll make it better later. This is not something that's happened. This is a bit different than federal legislation that moves at a lumbering pace. This is fast moving, and we have never seen a state roll cannabis legalization out inequitably and then magically become equitable.
This is Richard Walker. Has the equitable part in the New Jersey legislation ever gone through where the money has gone into those communities and localities throughout the state of New Jersey?
From Amber, do you want to take this question?
No, you can go ahead.
Okay, I'm unsure exactly. I know that they passed it that way, but they also do not have a fund the way that Virginia set up. We have a direct fund of allocations, the Cannabis Equity Reinvestment Fund, where it is just built into their tax system that they'll reinvest it into certain communities like education and that sort of thing. So it's actually just built into their tax structure. And I have not checked directly to see how that is going, but that would be my answer. I hope that answered a little bit, Richard.
I will say that something to really to be mindful of when it comes to states like New Jersey. One of the things that I think we believe that social equity programs do is create all this funding to help people enter the market. But that's not actually what they do. Only 6 states actually provide direct funding to operators and licensees, and not one of those has provided funding prior to the implementation of the adult use market. So what that means is that sometimes these applications and just the process of getting to the application, especially where there's requirements for you to have a premise, can be hundreds of thousands to upwards of $1 million just to apply. And so the funds are not there until later. And this is another situation here in Virginia where there would be funds coming in allocated supposedly for social equity businesses. But as we've seen, the laws change. And so that wouldn't be available for folks on day one. And so those are issues that we're seeing where states, even if the money is allocated, make changes, it is slow going. And that's why we really need to push states to make investments in advance and to prioritize restoring the communities.
Right. We're really here to say that we oppose the transitional market that gives that exclusive early access to medical operators without day one equity. We are hearing about the social equity business fund increase to 1 to 6 million. That I think is supposed to be something that really encourages us. But as Amber just said, if that money is not available on day one with everyone else, then it really is too little too late, and it could be changed and legislated and redistributed somewhere else, which happens very often. So again, why we are asking for this day one equity piece. Are there any other questions? Okay. Well, we will be posting this video. And if you have any other questions, please feel free to reach out to any of us at CannaJustice Coalition or MCBA. And we will obviously be following this until the end of session. And so I want to thank you to all of our partners that have signed on. They are really getting behind us with this now, understanding the importance that something probably will be passed with marijuana, because there are enactment clauses that have to be satisfied. So there will be negotiations coming through the pipeline. So we appreciate everyone staying tuned, and you can catch Marijuana Justice the first Wednesday of the month. Our next one is in March. It's Wednesdays at 6:30 on Zoom, and you can catch our February one with Amber Littlejohn, where she's really going into detail a little bit more about the exclusive early access and the danger of that. So again, my name is Chelsea Higgs-Wise with Marijuana Justice, as well as Justice Forward Virginia, Virginia Student Power Network, Rise for Youth. We make up the CannaJustice Coalition, and our national partner on this movement right now, Minority Cannabis Business Association, Amber Littlejohn. Thank you so much, everyone.